So in my previous video, I talked about several issues that I perceive within the Canadian Charter of Rights and Freedoms. In this video, I'm going to talk about why I don't agree with some proposed legislation before the Canadian government. Well, not 100% sure if it's been proposed, but it's been talked about a fair bit. The Canadian government's been talking about proposing plain packaging legislation for tobacco products. What this means is that there will be no branding allowed on the packages, which means the companies will not be allowed to put their logo on the packages of cigarettes they sell. The idea behind this is that it will make people less likely to want to purchase tobacco packaging because there will be less flashy labels and brands on it. Now, already, at least in the province of Ontario, it's mandatory that 75% of the packaging be devoted to warning labels about the health hazards of tobacco. And indeed, I don't think anyone can try and say they don't know at this point in their life what the health hazards of tobacco products are. And frankly, I like to make my biases known before I start something or discussing something. I hate cigarettes, despise them. I literally cannot help but cough whenever I pass by someone who's smoking. They irritate my lungs that much. But nevertheless, I oppose plain packaging on cigarette packages. Here's why. It's because I believe it to be unconstitutional. In Canada, Section 2 of the Charter of Rights and Freedoms, specifically Section 2B, guarantees people the right to freedom of thought, opinion, and let me actually find you the exact reading of this. Pardon me. Section 2, subsection B, freedom of thought, belief, opinion, and expression, including freedom of the press and other media of communication. Certainly, for any kind of brand that sells any kind of product, their logo is an expression of who they are as a company. And certainly, they are entitled to that right to express that on their packaging in Section 2 of the Charter of Rights and Freedoms. My concern comes with Section 1 of the Charter, which I spoke about in my previous video. My concern is that while I do believe fundamentally that these companies have a right to express themselves through their branding on their packaging under Section 2 of the Charter, that the judiciary system will use Section 1 to ignore that completely. And there's actually precedent set about this in regards to the tobacco industry in particular. The government has passed legislation in the past that outright banned tobacco advertising. They did that in the 1980s, when there was less information about the harm that cigarettes cause to people. And in the early 1990s, that legislation was shot down as unconstitutional. That is why in the 1990s, or perhaps the early thousands, I'm not 100% sure on this, the government enacted new legislation. It did not entirely ban the ability of tobacco companies to advertise, but it restricted it so heavily that it more or less amounted to a ban. This was challenged, and late into the 2010s, or perhaps the early 2000s, I forget again exactly the date, the Supreme Court ruled that while this current ban does violate the charter rights of the tobacco companies under Section 2, they use Section 1 to allow this to stand by stating that the health benefits provided to the public by prohibiting tobacco advertisement would be greater than the rights that they are impeding upon by prohibiting these companies from advertising. This means already there's precedent set that restricting the abilities of tobacco companies to brand themselves is for the greater good of the Canadian public. Now, frankly, I don't necessarily disagree with that. However, given that it is fundamentally an impairment upon the rights of the tobacco companies, I do have a problem with that. I have a problem with any kind of infringement upon someone else's right that is not derived from that person infringing upon another right of that individual. Now, it could be argued that the tobacco companies violate people's Section 7 rights. However, that is a very vague, very, very vague argument, because it would depend on what the definition of the security of the person is. And I hope to get into the Section 7 rights in a later video. Nonetheless, I fully expect that tobacco companies will be prohibited from allowing themselves to brand on their own packaging, and that when they challenge this law, the Supreme Court will allow it to stand using Section 1 as an override of the violation of their Section 2 rights. My concern with this is with something you've probably heard of before, the slippery slope. Now, many people will refer to the slippery slope as a fallacy, and in some cases it certainly is, such as the argument that people, usually fundamentalist religion people, make about gay marriage. They say that gay marriage will lead to bestiality or to incest or to something else like that, because these people view gay marriage as being morally as reprehensible as those things. Now, we know that not to be true, and that these things are completely unrelated. And in such a case there, the slippery slope is indeed a fallacy, because there is no relation between gay marriage and bestiality, or gay marriage and incest, or anything of the sort. However, tobacco companies are being restricted in their rights based on the idea of public health. And that does have several other relations to several other industries. The most notable, of course, being fast food. And admittedly, several tobacco companies and their coalitions for advertisement or rather lobbying, have used the association with fast food in the past in their own opposition to this. And indeed, that is a concern I do have. Tobacco was viewed as societally normal not even 30 years ago. It was everywhere and everyone smoked. Now, we all do know the health detriments that tobacco has, so we know that it's not a good thing to be smoking now. I think everyone knows that. The concern is, with me primarily, that this will slowly be used to start attacking the fast food industry in relatively similar fashions. Now, with the fast food industry, there's not really as much of a push, per se, as there is with necessarily the alcohol industry, because there are still temperance groups, despite the failing of prohibition in the 1920s, there are still temperance groups that are pushing to prohibit alcohol advertising and push for plain packaging on alcohol the same way they are pushing for plain packaging on tobacco. Now again, I don't agree with that. I also don't agree with any kind of prohibitions of advertisement of fast food. But that is my main concern, is that it will be used to target fast food, because we are increasingly becoming aware of the health problems associated with excessive eating of fast foods, given the presence of numerous things in these food products that are detrimental to people's health. Already in Ontario, they've mandated calorie counts on the menus in fast food restaurants, and to be honest, I don't have any problem with that. They're not prohibiting anything, but they're empowering people to make better choices for themselves. And that is something that I can support, and that is something I support with tobacco as well, is making people aware of the health problems associated with it, and let them make their own decision as to whether they want to put that kind of cancerous nonsense into their body. That is your decision to make. I don't believe it's the government's decision to try and tell you you can't do that, or to try and tell tobacco companies that they cannot express themselves for who they are on their own packaging, because while I might not smoke, I do know that there are differences between the different kinds of cigarettes available on the market. Indeed, this is a slippery slope argument, that it could lead to this somewhere down the line. Perhaps not with fast food, but perhaps with alcohol. As I've mentioned, there are temperance groups already pushing for it. And also perhaps with firearms and ammunition. Now, there could be pushes to put plain packaging on ammo, or to put warnings on ammunition beyond what there already is to keep them out of the hands of children, and to follow the safe and responsible rules of firearms ownership and firearms handling, which every gun and ammunition company puts somewhere on their packaging already. Already, tobacco companies are restricted to, as I said, only 25% of their package to express themselves on. Pushing any further than that is a quite blatant violation of their Section 2 Charter rights, no matter how reprehensible it might be, because of the health problems associated with smoking, and indeed the secondhand smoke that affects people around them, as I mentioned myself as well. I do not believe that invading upon the rights of any individual or corporation is something that should be acceptable. And that's why I do oppose plain packaging legislation for tobacco products. If you're still watching, thank you very much. This video might seem a bit different from the last one because I did it all in one shot, unscripted, and admittedly after a couple drinks. So that's why it might seem slightly different, maybe less professional, with a bit more stumbling words and phrases throughout the mix there. Again, I am Chris the Canuck, and thank you very much for watching. Please tune in again next week where I'll be discussing another issue in regards to the Constitution. As a matter of fact, I'll tell you I hope to discuss why I do not believe the Constitution explicitly prohibits the death penalty in Canada. Thank you very much.